Dear students, I welcome you to this class. So we are going to look at chapter number 8, and this chapter is about territorial sovereignty in the concept of international law. So the purpose of this chapter is for you to understand how international law governs the rights of states over their territory, including ownership, control, and protection of land, airspace, and territorial waters, ensuring peaceful coexistence, legal clarity, and respect for state boundaries. So these are the objectives for this chapter. So let us have an overview. So territory is one of the most important attributes of a state under the Montevideo Convention. So at the same time, sovereignty is one of the most important rights that attach to a state in international law. So sovereignty particularly implies exclusive control by a state over all its internal affairs or over any matter arising on its territory. So this exclusive control over matters arising on its territory is referred to as territorial sovereignty. So, territorial sovereignty of a state extends to cover multiple dimensions, and these include land, and that is the geographical territory. There is also subsoil, that is the underground below the land. So, there is also airspace, and that is above the land, excluding the outer space. There is also, for the case of coastal states, they also include territorial waters of that state. Also, the vessels, ships, and aircraft that are registered in that state in question. So there are many treaties and conventions which regulate state sovereignty over land, sea, air, and outer space. So let us look at exceptions to territoriality. So as noted, the general rule is that a state's prescriptive jurisdiction coextensive with its territory, that is, it extends as far as its territory. So there are, however, exceptions to this general rule. So in certain instances, international law will allow a state to exercise the prescriptive jurisdiction even though it has absolutely no territorial links to the matter. So let us look at these exceptions. We have nationality. So a state with no territorial links to a matter is entitled to exercise prescriptive jurisdiction over the matter if it has nationality links to the matter. So the concept of nationality is important since it determines the benefits to which persons may be entitled and the obligations such as conscription which they must perform. And many countries, particularly those with a legal system based upon the continental European model, claim jurisdiction over crimes committed by their nationals, uh, notwithstanding that the offense may have occurred in the territory of another state. So let us also look at the protective or security principle. So under this principle, a state may exercise jurisdiction over a matter to which it has no territorial links or nationality links if such states can demonstrate that its national interest was or substantially affected by the matter. So in this case, the state must demonstrate that it has been or will be affected in a serious way by the matter. So for example, that its national security is at risk or that its environment or the health of its nationals is seriously threatened by the matter. Let us look at the universality principle. So, under this principle, a state with no territorial nationality or protective effects links to the offense or matter may nevertheless exercise jurisdiction over the matter if the matter is of such a grave nature as to be of fundamental interest to the entire community of nations. So, one example of such matter are grave breaches of the Geneva Conventions of 1949, which under the conventions are subject to universal jurisdiction. That is, an alleged perpetrator of grave breaches may be prosecuted by any state that is a party to the Geneva Conventions, regardless of any territorial nationality or protective links. And there are two categories that clearly belong to the sphere of universal jurisdiction, and these are piracy and war crimes. So let us look at how these jurisdictions are enforced. So a state, in addition to having prescriptive jurisdiction, that is jurisdiction to set the rules or laws, may also have jurisdiction to enforce such rules or laws. So that's why the international law prescribes a stricter set of standards for enforcement jurisdiction than it does for prescriptive jurisdiction. So let us look at jurisdiction over foreign ships. So jurisdiction over foreign vessels, whether it be a ship or an aircraft, generally have vets in the flags states, and those are the states where such vessels are being registered. So at the same time, the freedom to use the world's marine sources is one of the oldest principles in the customary international law. But in recent years, that freedom has been clawed back by the coastal states that are keen to exercise greater control over the seas, oceans, and other maritime bodies. So let us look at the concept of internal waters. So according to the United Nations Conventions on the law of the sea, uh, a state's internal waters include all waters on the landward side of the baseline of states' territorial waters, apart from those states that are composed of several islands. So this includes waterways such as rivers, lakes, and canals. So internal waters are regarded as integral part of state territory, and as such, the state enjoys full and exclusive sovereignty over them. So a foreign vessel located in internal waters is subject to the sovereignty and jurisdiction, both civil and criminal, of the state in question. So let us look at the concept of contiguous zone. So this refers to waters located on the seaward side of the territorial waters of the coastal state. So within contiguous zone does not exercise sovereignty but only specialized powers, including powers necessary to prevent violations of its laws within the territorial sea. So, for example, the coastal state can stop, search, and bring to court foreign vessels in its contiguous zone if such vessels are about to commit or have committed violations of the coastal state's law in the territorial waters. So let us look at the concept of exclusive economic zone. So the exclusive economic zone refers to waters situated within a radius of 200 nautical miles from a coastal state's baseline. So as with the contiguous zone, the coastal state has no sovereignty over the exclusive economic zone, but merely a specific set of rights and duties. So these include rights of exploring, exploiting, conserving, and managing the natural resources, as well as rights to undertake other activities for the economic exploitation and exploration of the zone, such as production of energy. So, lastly, let us look at jurisdiction over foreign planes. So, under international law, the main treaty governing a state's exercise of jurisdiction over foreign aircraft in states' airspace is the Chicago Convention on International Civil Aviation of 1944, which has been ratified by 191 states. And under this convention, every aircraft must have a single nationality, which is of the state in which it is registered, and that is from Article 17. So I have attached the reading materials for this chapter. In case you want to make more research or read more, please go ahead and use these materials. That's all for now. Thank you.